Thane is going to take it to council if necessary.
Great. We have quorum. Members of the committee, please, if you can take a seat. Good morning. Yeah, we do have a quorum. Fantastic. I'm calling this meeting to order. Good morning, everyone, and welcome to our 14th meeting of the Licensing and Standards Committee meeting during this term. Also, I would like to extend a warm welcome to members of the public and those who are watching live online or on TV. As usual, I would like to remind everyone that you can find the agenda for today's meeting and follow the meeting in real time at www.toronto.ca/council. Conflicts of interest. Are there any declarations under the Municipal Conflict of Interest Act? If none, we'll continue. And can I have a motion to confirm the minutes of September the 25th, 2016? Councillor Di Giorgio. All those in favor? Against? Carry. Thank you. The speakers, we have this green sheet that's been circulated with some speakers, and so please refer to that one. Communications. There is a communication from the chair as it relates to, and dated October the 21st, that's new business, and that needs to be introduced. Have you had a chance to read this communication? It refers to the enforcement of railings in apartment buildings. Yeah. So can I have a motion to introduce this communication? Councillor Ibermaker. All those in favor? Against? Carry. So that item is part of the agenda. Now we have, we have 4 items. Actually, on the last item that was introduced to the agenda, in terms of its disposition, what I would like to suggest is if we can refer this item to the Executive Director of Municipal Licensing Standards for her consideration. To city staff. Yeah. All those motion to adopt. All those in favor? Against? Carry. Great. So we have 3 items on the agenda, and I will go through it briefly and hold those items that we have speakers. The first item, LS 14.1, powers of the Chief of Toronto Police Service to approve properties for the removal of parked vehicles. And there was a registered speaker, but I understand, and he has withdrawn his name. So, is there anyone in the audience who would like to speak on this item?
Mr. Chair, I have questions on this.
On the item number 1?
Number 1.
Okay, so that item is going to be held. Item 2, we have speakers, and item number 3, we have speakers, so the 3 items are being held. So having said that, we'll just go to deputations now. Item number 1, powers of the Chief of Toronto Police Service to approve properties for the removal of parked vehicles. And no deputants visiting members of council. Councilor Nunziata, questions to staff?
Well, I have an issue, and I'm sure other members of council have the same issue, where there's a landlord or there's a strip plaza where they have cars parked, people are parking in their parking lot illegally, and they're parked there from apartment buildings or whatever surrounding area. So they want the car towed from their property, and they're told that they have to contact they have to contact parking enforcement first, and then, and they have to wait for the approval from parking enforcement, then hire a tow company to remove them, correct?
Through you, Mr. Chair, that sounds like that's the approach that parking enforcement has taken, yes.
Yeah, but in that case, though, the problem is that what I've been getting is that when they do call for park enforcement, it takes hours and hours for them to come and respond to the call. So unless they come and give approval that these cars can be towed, they're not allowed to tow the cars, correct?
Correct.
So there's a little problem there?
So through you, Mr. Chair, so this report, Councillor Nunziata, is to ensure that those types of parking lots that employ municipal law enforcement officers who can do the towing and tagging on private property. This is a technical amendment to make sure that they've got that authorization from the Chief of Police. So it's not only the Toronto Police Service Parking Enforcement Unit that can do it, and that's actually the impetus to a lot of this. It's municipal law enforcement officers trained and certified by the Toronto Police Service Parking Enforcement that are licensed by us that can undertake those activities. So many private property owners that have this issue are utilizing that resource as opposed to Toronto Police, because a private property issue is a lot lower priority.
So they have to sign a contract with it?
That is what many private property owners are doing because of this issue, because a private property complaint for the Toronto Police Service Parking Enforcement Group is a lower priority. They're focused on rush hour and other on-street parking issues. So this is really just a technical amendment to the existing bylaws to ensure that that MLEO process is proper.
Yeah, I realize that, but I wanted to take this opportunity to ask that question because I'm sure that so the private company that they hire has to be on standby? Like, how does that work? If they have 20 or 30 cars parked on their property and they want them all towed, they just call this private company and they'll come immediately to tow them? Is that the way it works?
So through you, Mr. Chair, many private property owners do contract with, and typically they're security companies. What I could suggest, Councillor Nunziata, is we can speak offline and we could put something together for you to help you inform your private property folks that are having this issue on what their options are, if that would be helpful.
Okay, that's fine. Thank you.
Okay.
Great. Thank you, Councillor Nunziata. Any other questions? Councillor Mamaliri.
We're talking about private property and the rights for our municipal police to tag and tow away. That's what this is about?
No.
Okay.
No, they already have that authority.
On private property?
Correct.
When did that change?
It's always been there.
To tow away?
They can,
private property?
through you, Mr. Chair, as long as the private property owner authorizes the removal.
Okay, so that's my point. Unless there's a bylaw that's on a private property, nobody can tow anything or tag anything.
Through you, Mr. Chair, that's correct. There's proper signage and other rules required.
Right. And when there aren't the bylaws clearly placed on private property, the owner of a vehicle that had been towed, if there's no bylaw that is warning them of the infraction, doesn't have to pay any charges, even if they get towed and the tow truck company tries to charge them. In fact, that towing company cannot charge them. Am I correct?
So through you, Mr. Chair, that's going to come down to a civil and/or contractual dispute matter.
We dealt with this a number of years ago in council, and it was determined, in fact, back then I even tested it, where I left my car purposely somewhere to see where it would be towed. And then I went to retrieve my car, and I insisted that they're breaking the law, that you cannot charge somebody unless there's a visible sign an infraction of a bylaw has been broken. And in fact, they released my car and agreed with me that they couldn't do it. So shouldn't we let the public know that that's actually the case, that you just can't tow somebody's car because you feel like towing it, and then charge them the exorbitant amount of fees to collect the car?
So through you, Mr. Chair, I think your point is valid and your situation is accurate as you describe it. Chapter 545 does prohibit the charging of towing fees and impound fees in circumstances where it's improperly towed. So that does exist already in municipal bylaws.
Right. So if we're trying to make attempts to get cars towed without a bylaw being enforced, we are doing an injustice to people who are leaving their cars without being properly warned. Right?
Sorry, through you, Mr. Chair, that's not the intent of this report.
What's the intent of the report?
This report was to make some technical amendments. It's drafted by our city solicitor. I don't know if our solicitor here is up to date on it.
Yeah, so just to be clear, through the chair, the intention of this report is to essentially align the municipal law enforcement officer chapter in the municipal code with recent revisions in chapter 545 relating to commercial parking lot operators to essentially allow the chief of police.
Private commercial property owners?
That's correct. To allow the chief of police to make decisions on revocation, suspension, or non-approval of those licenses.
That's with the commercial owner agreeing to a bylaw that's going to be visible to all drivers on that property.
So that's correct, through the enforcement of posted information of those infractions. That's correct.
Okay, thank you.
Thank you, Councilor Mamalieri. Any other questions? If not, I have two questions for clarification purpose. So these technical amendments are required as a result of City Council adopting the regulations for the licensing of commercial parking lots and to improve mainly the enforceability of the municipal code in terms of licensing and the zoning bylaws. Is that?
Very well summarized, yes.
And the second part, it also clarifies the powers to the Toronto Police Service Chief to approve properties for enforcement purpose, especially with the municipal license enforcement officers,
Correct, it's required.
and to allow them the powers to suspend or revoke approvals if there is not compliance with it.
That is correct,
So that's the purpose of these technical amendments.
absolutely.
Thank you so much.
Thank you.
And any other questions? Councilor Karygiannis.
Thank you, Chair. Through you to staff. Can you please describe to us what visibility means on a private property? Is it one sign, two signs, three signs? If there's, let's say, 500 cars, how many signs would you require? What is the visibility rules that that park on that property are able to see it?
Through you, Mr. Chair, we did bring the commercial parking lot section of 545 previously. I don't have it in front of me, but there are rules requiring clear signage. The signs need to be approved by the Toronto Police Service Parking Enforcement Unit as well. I don't know that we've identified a number, but just that it had to be clearly visible and, as noted, approved by the police service.
There is. Do you want to stop my clock just in case? Thank you. Through you, Chair. If I am in a plaza, for example, and the plaza has one sign, two signs, three signs, but I'm parked on the rear end and this is not visible to me, and they say, well, the sign was over there, you didn't see it, we're going to tow you. I mean, what is the proximity to a parking location that I must have this sign visible in a private property?
Through you, Mr. Chair, I do have the provisions up on my laptop. The signage requirements under Chapter 545 for commercial parking lot operators impose a requirement to sign the entrances to the commercial parking lot, and there are specific standards in terms of sizing of letters. They must be of uniform size, not less than 7.62 centimeters in height, and must be at every public entrance, and not less than 2.54 centimeters in height at each pay station. They must be readily legible. They must be posted, and they must include the hours of posting for the business, and they must include the operator's name, business name, license number, telephone number, and contact information. So it does have pretty specific standards.
How many plaza owners or commercial parking lots have we charged so far, or we've cautioned so far for not having those requirements?
Through you, Mr. Chair, I'm not aware of the enforcement stats related to commercial parking lots, but I also note you might be making a distinguishing between commercial parking lots that are licensed by us and strip plazas exercising their private property rights. But I am not aware. We can certainly find out and get back to you.
Let me rephrase the question. How many plazas have we charged in the last couple of months that you're aware of people not having the proper signage?
So through you, Mr. Chair, the distinction there, sir, is we do the enforcement relative to commercial parking lots that are licensed or ought to be licensed by us, subject to Section 545. Private property, strip mall property is not an enforcement issue that we have, so I would not be able to answer that question if private property strip mall owners are having vehicles towed unlawfully. That would be more of a police matter.
Can I ask you please to get us those figures, to get me those figures for, let's say for Station 42, how many, which is my part of the world, how many strip plazas have been cautioned, charged through the police for not having the right signage when you enter the plaza? Because I can tell you, if I was to go around my ward, I'd probably find one or two that have the appropriate.
So through you, Mr. Chair, there is a difference between the provisions that our lawyer has read out in respect to commercial parking lots, commercial parking lot operators that are licensed by us and the requirements they have, versus what I believe you're asking is about strip plazas that simply are required to have private property signage, but that's not governed by us or required by us. In order for someone to remove the vehicle from private property, they have to have proper signage.
Let me ask the question again. So I appreciate that. I thought the lawyer, I could be wrong, but gave us the understanding that this was also a matter that private strip plazas have to have signage up. Am I correct?
So through you, Mr. Chair, just a point of clarification, the term commercial parking lot operators is meant to encompass those parking lot operators who are charging rates for cars to be parked. They're not for in the situation I think I understand you're describing where parking is permitted without charging of fees.
So last question, Chair. So if I go into a plaza and there's no signage up and I get towed, then who do I call and who do I hold responsible? And why are we letting these folks get away with murder?
So through you, Mr. Chair, that would be a matter that should be reported to the police and investigated by the police. Part of what we have here is the licensing of municipal law enforcement officers who can do tagging and towing from private property, but only after it's been approved by the chief of police for such activity and certified by the parking enforcement unit of the Toronto Police Service. So those that have complied with the law have those requirements. Strip plazas or other property owners who may be acting otherwise, then we're into a police issue.
Thank you. Councilor DiGiorgio.
Just a very quick question. So these private property owners, if they want to put up signage, what's the process they go through? I mean, do they just put them up, or is there a bylaw that they have to comply with, or?
So once again, through the chair, if the operator meets the definition of a commercial parking lot operator, there are specific rules in Chapter 545 governing how the signage is posted, the size of the signage and the writing, where it should be posted, and the information contained upon it.
But who do they apply to?
So approval of the licensing of municipal law enforcement officers is part through the chief of police. So part of the enforcement requires the chief of police to review this information, or at least the individuals acting under the chief's direction.
To review the signage before it goes up and where it's located. The chief of police does that, or his department?
So the chief of police is required as part of the issuance of approval to review these matters. Information is also provided to municipal licensing and standards under Chapter 545, including, I believe, a photograph of the signage.
Okay, thank you.
Thank you. Any other questions?
As a point of explanation or a point of order, what you want to call it, what do we describe as a service animal?
Hold on, there is no points of clarification, you know more than that. I think what you're referring is the second round of questions.
I have one question, Chair.
Okay, with the Is members of the committee are okay with that? One more question? Okay, please.
What do you describe as a service animal? Does that also capture the service animals that are actually for?
That's the next
suffering from
that's the next
PTSD?
report. That's the next item. That's the next item.
Service animal.
14.2.
Yeah, that's the next item.
sorry.
We're still in number 1. Okay, thank you. So, you are just a little
We're
bit
going
ahead.
to the animal.
Okay. Come on, members of the committee. Okay. Is any speakers on the item? Speakers on the item? Councilor De Vermaker. Is okay. Councilor De Ver, any other speakers? If not, okay. So the staff's recommendations have been moved by Councilor De Vermaker. All those in favor? Against? Carried. Thanks so much. We'll move to item number 2. And we have deputants on this item. We have speakers. Is Miroslav Glavic. Glavic, sorry. Good morning. Good to have you here. And sorry if I mispronounce your last name.
Oh, well.
Please go ahead.
My definition of a service animal is 1, a dog, 2, my future mother-in-law. I so wanted to say that for a long time. And I know I'm getting in trouble. She's taking care of the kids. Where is it? One issue, where is it? About the limiting of how many service animals is. Technically speaking, that where is it? Follows under AODA, which is provincial law. There's 5 people. 5 people living in my house, including me. At one point, I had my parents and my girlfriend's that doggy, my mother-in-law living. If I remember correctly, the city apparently limits to 2 people. If there's 5 people in one house that need some kind of service animal, AODA says that supersedes the limits the city, because the provincial law supersedes municipal law. It's good that you're deleting that disabled person. Where's the other one? There is one section that says that you're not requesting service animals from getting the license and all that. When I got my license for my dog, they put the microchip if it gets lost. A person with a service animal, if the service animal decides to run away because of a squirrel or whatever, it's more harmful than if Councilor Mamoliti's dog. You have a dog? If his dog would run away, so that there should be a requirement for all, even people with service animals, to have the licensing. You could reduce it like you reduce for seniors. My dad is a senior and he has a dog. He has reduced fee, but the important part is the microchip to identify dog, because most dogs of certain breeds look the same. And I fully agree that you should exempt people with, I don't like saying the word disabled person, because that's, or even the word disability, we're all the same, no matter what health issues we may have. It's good that you're not limiting the animals. And for most people, the definition of a service animal is a dog. Some people say a cat. An iguana is not, or a snake are never going to be service animals, you know. Where is it, one thing? Never, you should never, even if you try to put a limit on how many service animals somebody could have, they'll just sue the city via AODA, which again supersedes anything that the city may or may not want to do. Thank you.
Thank you, Mr. Navich. Any questions to the deputant, visiting members or members of the committee? Thank you for your presentation. Any other speakers that would like to speak on this item? If not, we'll bring it into questions to staff. Is visiting members. And we'll bring into committee is, oh no, Councilor Nunziata, you're the first one.
So if I can ask staff on this report, if you can explain a bit what the report is, and because I have an incident in my ward, I just want to get some advice from you if it applies to that. Okay, if you can just explain it to me, please.
So through you, Mr. Chair, the purpose of this report is to amend 3 bylaws that make reference to service animal and to ensure that the definitions now are in line with the new integrated accessibility standards regulation. On page 3 of the staff report and carrying on to page 4, it identifies what is now being defined as a service animal. So a service animal for a person with a disability. If the animal can be readily identified as one that is being used by the person for reasons relating to the person's disability, and it outlines which members of medical colleges can sign for someone's use of a service animal. So just we're making sure that these 3 bylaws are reflective of the recent amendments to the accessibility standard subject to the AODA. So just want to make sure we're in line with provincial accessibility legislation.
So if an individual has a service dog, they cannot be denied of any access.
That is correct.
Right. Okay, because I have an incident in my ward where I have this woman that's blind, and she has a service dog, and she's being refused access into a taxi cab because she has a service dog.
So through you,
does this?
So through you, Mr. Chair, well, this would still apply as well,
Yeah.
but we already have in Chapter 545 and 546 that service cannot be refused to someone with a service animal. Obviously, the challenge is very difficult with ones in taxi cabs because of the people's fears or concerns about animals. So we try to balance that through education with the industry, that they, by law, cannot refuse service, but we do recognize the proximity of drivers to passengers, so we're working through that. But by the law, no, they cannot refuse.
But they are doing that.
And if we are made aware of it, we will investigate it and we will take the necessary action. We did have to make those changes to Chapter 545 last year, the year prior, because we had some restaurants that were refusing people with service animals. So we made amendments then. This is now updating those amendments again to ensure they reflect the new standard as of July of this year. But if someone does encounter that issue, then they ought to notify us and we'll investigate it.
Yeah, I've had someone in my ward for the past year that has, and we finally we had a meeting, but I just, you know, I just found that shocking, you know.
Through you,
that that was happening, you know.
Through you,
And
Mr. Chair,
unfortunately,
we
she
have heard
doesn't
that.
know what the cab number, because she's blind, right, so.
So I can add, through you, Mr. Chair, I can add as well, Councillor
Yeah.
Nunziata, that the province is currently looking at the transportation standard as well. Myself and Vanessa Fletcher both have been quite involved with these discussions, and we do recognize, and we have heard from people as well through our Disability Inclusion Access Committee, I might have the letters backwards, that this is a challenge, including for people who are visually impaired and can't identify the taxi cab number.
Right.
But I would, even minus that information, it would be helpful for us to know that it's going on, and we'll do whatever we can to investigate and take appropriate action.
Thank you.
Okay.
Thank you, Councilor Nunziata. The next member is Councilor Di Vermaker. Please go ahead.
Thank you, Mr. Chair. I just thought I would use the screen to make sure I have my understanding correct. So this is a service duck that was profiled in the Toronto Star, so it must be true. So according to our bylaws now, if I have a service duck and I take him into a restaurant, my service duck would be allowed to go into the restaurant?
Through you, Mr. Chair, as long as the animal meets the requirements as spelled out by the ASR, the regulation, and it does not prescribe types of animals, it merely prescribes the documentation required to support that type of animal is necessary for service purposes.
So if I go into a fancy restaurant with my service duck, you're guaranteeing me that my duck will come out alive?
Through you, Mr. Chair, if it was my restaurant, I could guarantee it because I wouldn't eat duck. But unfortunately, I can't speak to the conduct of others. But certainly, any person with a service animal, and joking aside, any person with a service animal does have the right to fair access and cannot be refused service.
Okay. And just my next question in terms of service animals, if one of my therapists, because I have many, if one of my therapists that are on this list tell me I need a service cat to deal with my anxiety, you're saying to me that at the next meeting, I could bring my service cat here and I would be okay? Or committee? Sorry, I think there's a legal discussion going on.
Sorry, through you, Mr. Chair, our good counsel was just bringing to my attention the notion of prohibited animals as use of service animals would be problematic because Chapter 349 still applies, but a duck doesn't fall under the prohibited animal, so you're fine on the prior answer. I'm sorry, in respect to your question about the cat?
So if one of my therapists, because I have many therapists, if one of my therapists said to me, Glenn, you need a service kitten to help you with your anxiety, I would then be allowed to bring it to this committee meeting next week, or next month, I should say.
Through you, Mr. Chair, I would defer that to our friends from city clerks and from council in respect to the appropriate conduct and what's permitted at committee meetings. And I know Councillor Nunziata is not a fan of animals, is an allergic. So.
But the Act would, you cannot deny me access if I have a service kitten.
I would not deny you service or access.
Thank you, Mr. Chair.
Councillor Mamolidi, you're next.
Well, I'm going to take the other side of this equation. What constitutes a service animal? What's the definition, and what type of animal is a service animal? Because we're already getting into this whole concept by Councillor DeMaramaker that everybody and their cat and dog and snake and ferret and everything else can be allowed somewhere.
So through you, Mr. Chair, what is defined as a service animal for the purposes of accessibility legislation is very broad. The Act and the regulations prescribe that it is any animal that can be readily identified as one that is being used by a person for reasons relating to the person's disability as a result of visual indicators such as the vest or harness worn by the animal, or if the person provides documentation from one of the following regulated health professionals confirming that the animal is a service animal, and the list...
Sorry, say that again?
From a qualified health professional confirming that the person requires the animal.
What does that mean, a qualified health professional?
So there is a specified list. It's a member of the College of Audiologists and Speech-Language Pathologists, College of Chiropractors, College of Nurses, College of Occupational Therapists, College of Optometrists, College of Physicians and Surgeons of Ontario, College of Physiotherapies, College of Psychologists.
So if your speech therapist says you can carry around your ferret because I said so, nobody can deny that ferret into any room?
So as the Executive Director has pointed out, that is correct for the purposes that it becomes a service animal under the law.
So if a speech therapist wants to say that this tiger helps my clients speak a little more succinctly, that particular tiger or lion can be in the room as long as what?
So again, through the chair, to be clear, that animal would become a service animal by law. However, there would still be regulations under Chapter 349 prescribing prohibited animals in the city.
Okay, so that particular chapter speaks to snakes?
Through you, Mr. Chair, I don't have 349 in front of me. We'd have to check the list. But I think the important point, if I may, is that there are a number of recognized professional colleges of medical professionals that have been identified as the people who can provide that authorization. So I would have to trust.
Some of them are nuttier than me, but I'm more inclined to find out who is going to ask one of those therapists to approve a snake being that service animal. I'm not exaggerating. I think people will try to do this. So how could we as a city feel comfortable knowing that restaurants aren't going to be forced to let snakes in, or ducks for that matter? I think it's ridiculous. How does a duck become a service animal?
So through you, Mr. Chair, you know, I believe the nature of this conversation really is one that needs to be taken up at the provincial level in respect to how they are defining service animals subject to the integrated accessibility standard. We have not rendered a decision on what is or is not applicable or appropriate for service animal. We're simply reflecting in our bylaws the provincial law that's governing this. You know, I think to answer your question on snakes, if they're greater than 3 meters long, they are prohibited.
All right, so let's go back to somebody who needs a service animal. If it's determined that a person needs a cat as a service animal to calm them down, that would be acceptable, and anybody would have to allow them into either their vehicle or their establishment, right?
Through you, Mr. Chair, that's correct.
If the same person and the same therapist said they need a boa constrictor snake to make them feel comfortable, we would say no to that.
Through you, Mr. Chair, we would rely on Chapter 349, Animals Bylaw, if it falls under the prohibited animal section, though I will note that could be subject to challenge because the provincial legislation does not indicate what type of animals can or cannot be service animals.
So in fact, a lion can be a service animal.
So again, through the chair, that is correct in the definition under provincial law. It is.
You see how ridiculous this is going to be?
So through you, Mr. Chair, I don't know that it's appropriate, sir, for us to comment. The purpose of this report was simply to ensure that the 3 bylaws we have that are not updated are updated to reflect the provincial standard. Certainly, if there are some concerns of that nature, provincially would be the place to take it up.
Well, wouldn't an
Thank you. That was the last
appropriate
question,
motion
Councilor
just-
Mamoliri. We can come back again.
Okay, I'll speak.
I had the vice chair next, but I had a couple of questions for clarification purpose. Actually, hopefully that's going to help. Or just go ahead and then I'll ask my questions.
Thank you. Can you tell me, please, through the chair to you, staff, can you please tell me, are we allowing service animals, especially to do with servicemen, veterans that have been suffering through PTSD, will this be captured?
So through you, Mr. Chair, as long as that person meets the requirements as spelled out in the integrated accessibility standard laid out by the province, which includes, as Mr. Lynch referenced, the documentation from a number of medical professions, then it would be captured. As long as this is met, they would be permitted, irrespective of their condition or concern.
Through the chair to staff, the reason that I'm asking is that the federal government is still trying to figure out if service dogs, especially for veterans suffering with PTSD, is something which is useful. Now, if a veteran or somebody that suffers from PTSD or other ailments were to show up at a restaurant and they have the dog has the appropriate tags or on their back that says this is a service animal, will that be allowed? Will we enforce the rules and say to the restaurateur or to any other institutions that this animal has to be allowed in?
Through you, Mr. Chair, we have taken that action. So I'll just point you to page 4 of the report. If an animal is readily identified as one that is being used by the person for reasons relating to the person's disability, we can then go back to the definition of disability as well. Then they would be permitted. So as long as they are meeting the definitions as prescribed, the definition of disability under the AODA is on page 5. So as long as those conditions are met, or on sub B on page 4, it talks about documentation from a health professional that permits the animal, then they would be permitted. And our bylaws reflect the requirement to allow them service.
Thank you, Chair.
Thank you. A couple of questions. I think just with all the questions that we have, it's becoming a bit confusing. And so for clarification purpose, the technical amendments that are recommended in this report as it refers to the Toronto Municipal Code, Chapter 545, on the licensing aspect, Chapter 349, as it relates to animals, and Chapter 609, as it refers to parks, it's simply to include the current definition of service animals to provide that kind of exemption to persons with disabilities. Is that the intention overall?
To you, Mr. Chair, that is correct, to ensure those three bylaws are updated to reflect the current definitions and ensure that they meet the standards as laid out by the province. There are provisions existing in those bylaws already. They need to be updated to meet the current changes as of July 1, 2016.
Furthermore, so these amendments will reinforce the expectation of inclusive treatment of all customers and residents in the city by ensuring that persons with disabilities accompanied by service animals are treated equitably. Is that the intention overall?
That is absolutely the intention.
So the proposed updates also within these chapters reflect also the current provincial standards under the Accessibility for Ontarians with a Disability Act. Is that the intention as well?
Yes, sir.
So my last question is, there has been a number of questions and perhaps there is quite a bit of merit in terms of the line of question is that as it refers to the definition of what constitutes and service animals, tigers, lions, snakes, ducks, and that kind of stuff. Will there be any further reports that clarifies that definition?
To you, Mr. Chair, no, there is none intended. Until such time as if there's any amendments or other changes to the provincial legislation that would require us to update our bylaws, in that case, then we would. But otherwise, no, this is just to make sure that our bylaws are reflective of the current state of provincial legislation governing people's rights and accessibility.
Thanks so much. The speakers on the item. Visiting members. If not, we'll bring into committee. Councillor De Vermaker, you're first. Please go ahead.
I'll move the staff recommendations.
The staff recommendations have been moved. The next speaker, Councilor Mamoliri, followed by the Vice Chair. No, just Councilor Mamoliri. Please go ahead.
Just to be clear, I'm not going to not vote against the recommendations. I just want to make it clear that municipally, no matter what, under whatever piece of legislation we're talking about, or bylaw for that matter, if it's determined by one of those professionals that their client needs a service animal of some kind, it's not limited to any kind of animal. So let's get that straight. We heard that from staff. So as small as an animal can be, or as large as an animal can be, if one of those therapists, being a speech therapist or otherwise, suggests that their client needs a reptile as a service animal, our restaurants, our cabs, our rooms in the city cannot refuse that particular animal. Let's be perfectly clear about this, because I think that once people get an idea that all they have to do is go to their speech therapist and suggest that their reptile can come with them wherever they want, that's exactly what's going to happen in the City of Toronto, right? So I'm not a fan of that particular kind of reaction to this. I have no issues with service dogs. I have no issues with that at all. I think that most people would expect that kind of help. But when we start bringing our monkeys around because our speech therapist says it's going to make us feel better, then this bylaw is not right for the City of Toronto. And I think that could potentially happen here. So let's be very careful. And if we have to make suggestions or recommendations to the province to change that so that we can make the changes accordingly to our bylaws, then that's exactly what we should be doing. I should have moved the motion earlier. But Mr. Chairman, if you accept the motion, that's exactly what we read, that we would ask the province to relook at its legislation around the types of animals that could be considered service animals. If you accept that motion.
Perhaps you might want maybe just to think about that at City Council,
Should bring it to City Council?
if that's...
Into the circus itself?
No, that's your choice in terms of the recommendation itself. Is you just...
All right.
Okay.
All right.
Unless if there is any other member who wants to move
You
that.
can do that if you want.
Okay. Thank you, Councilor Mamoliri. And okay. The next speaker is Councilor Carichanis. Did you? Oh, you're okay. Okay. So what we have before us is that Councilor De Vermaker moved the staff's recommendations. All those in favor? Against? Carry. Fantastic. So we're moving now to the last item, and we have deputants as well. And on this one, we are dealing with LS 14.3, feasibility of implementing an alternate dispute resolution process. This item ended up in this committee via City Council through a notice of motion by our esteemed colleague, Councilor Holiday. So the first speaker that we have is Peter Brewer from St. Stephen's Community House. Good morning, ma'am. If you are kind enough to state your name, welcome. Good to have you here.
My name is Catherine Feldman Axford. I coordinate the community mediation program at St. Stephen's Community House. And Peter Brewer asked me to come and speak on his behalf. Mr. Chair, members of the committee, I want to thank you for allowing us to speak on such short notice. St. Stephen's Conflict Resolution Training has been providing services to the city for over 30 years. A lot of that has been around neighbor disputes. We have been talking with various people in bylaw, including the executive director and Peter Hardesty, around finding a way to divert some of the cases that where there are inappropriate complaints being sent to bylaw and diverting some of those to us. Our idea is to try and create a more harmonious neighborhood through helping people learn how to communicate better and have better relationships. We do get occasional referrals from councillors and occasional referrals from bylaw at this point. We believe there are probably many more that could be, and that maybe if it was somehow written into the standards that be part of the process, that maybe more such situations may be sent to us. We've also had referrals from parks, from community development, very few. Most recent was maybe about 2 years ago. We have done and we continue to do situations involving city departments and residents in some cases where there are certain kinds of disagreements. We've also been getting referrals from Amanda Ross from the City Prosecutor's Office. Our belief is if it's going to end up being sent to us, it would be more effective if it was sent to us earlier than that. Such diversion programs are in place in Kitchener, in Mississauga, in Winnipeg, various places in the United States as well, where they have mediation written into the procedures when it's appropriate. Situations similar to the one that was recently in the papers from Councillor Holyday's area, where there are 4 neighbors who are all disagreeing. Those kinds of things are exactly the kinds of things we've been doing for 30 years. We mediate many kinds of neighbor disputes. It started 30 years ago, and we still do that along with other things. Currently, amongst other things, we're mediating in private information court, or what we refer to as private information court, where there are private complaints going to criminal court, where an ongoing relationship, such as neighbors, has broken. Those are being diverted to us to mediate a more lasting agreement than what asking people to stay away for 12 months. After the 12 months, someone's going to want to retaliate. And similarly, sometimes with the bylaw situations, someone complains a bylaw infraction is found, then the other person's mad, they'll start complaining back, and it starts being a sort of tit-for-tat situation. We're now a vendor of record for the Committee of Adjustment disputes in a new pilot project. This can resolve a number of the issues. However, we think that if it was written into this process, before it gets to Committee of Adjustment, we could be resolving a bunch of these, so it wouldn't even have to go that far. So we urge staff to study the feasibility with true curiosity and being open to writing in alternative dispute resolution options with an early resolution stage through referring appropriate cases for mediation. We're suggesting that because we're already receiving money from the city and have been for 30 years for doing this kind of thing, that maybe we could be at least one of the possible places to go to sort this out. There are also 2 other services in Toronto that offer community mediation. One is Warden Woods in Scarborough, and the other is the Canadian Multicultural Mediation Services, which generally services the Afro-Canadian diaspora in the city. We work collectively. I know with some services, the preference is to have one body that can filter through and then assign out. St. Stephen's serves the whole of the city of Toronto with the exception of Scarborough. So just to give you a sense of our scope, we utilize citizens who are all of your constituents as volunteers, and they're the ones who provide the mediation services. So again, it's people who live in the communities that we serve and who have a stake in wanting to address these situations.
Thank you. Thank you for your presentation. We have questions for you. Visiting members of Council, Councillor Holiday, followed by Councillor Nunziata. Please go ahead. 5 minutes.
Thank you, Chair, and thank you for coming to talk about the service that you offer. I know one of the things that I've struggled with in the types of situations that you respond to is sometimes just taking the first step. And it's gone so far that we've received guidance as councillors about what you can and cannot do in situations of enforcement or these type of conflict situations. And it's hard for me to simply just go and knock on someone's door because there's a balance, right? You're being a helpful community member, but you're also maybe using the weight of the councillor's office. Can you describe a little bit about what your service can do to initiate somebody coming to the table, and maybe you've got a little more freedom than maybe I have to reach out to affected parties?
Sure, absolutely. Again, I mean, we often get phone calls from one party in a dispute, and they may not necessarily know how to get hold of the other party, in which case we will do things such as Google searching people's names to see if we can find a phone number and things like that, or we'll send a letter. Which describes a bit about the service. Sometimes what we'll do is initially just ask people if they'll meet with the mediators and not even necessarily meet with the other party yet. And just that gives us a chance to assess the situation a little further to make sure it really will be appropriate, that we're not putting anybody in any situation that's unsafe, that people are prepared to mediate in good faith, and that they are prepared to follow through with whatever resolutions the parties come up with. Again, we don't determine the resolutions, the parties themselves do. So it's always things that they feel they can see through.
And one other question, our bylaws they're very black and white. Things are a certain measurement, the quality of a finish is there, an action is taken, action is not taken, something is in good repair. As a mediator, are you seized with black and white, right and wrong, certain sizes, or is your object something else?
Our object is more to do with getting people, in this case, neighbors, to be able to get along in what we refer to as repairing relationships. So I would say mostly as mediators, we deal in all those shades of gray that are between the black and the white. And I know that to some degree the bylaw offices are driven by a complaints-based process. And in this case, it would alleviate some of that, because I know, again, that the bylaw offices are probably challenged to keep up with the number of complaints in some cases.
So I guess it would be safe to say that you're not there to do the work of enforcement or to even arrive at a conclusion with respect to the bylaw. You're there to repair a relationship, which would be the root cause of some of these issues.
Exactly.
Thank you.
Thank you, Councillor Holiday. Councillor Nunciara, please go ahead.
Yes, thank you. So I'm very familiar with your services because I believe we've used it in the past. But what is your success rate on settling neighbors' disputes?
If we can get both parties to agree to come to the table, generally about 80% of the time they come away with a mediated agreement. The reality is, and this is across North America with some of these other services that we've been talking to and that I mentioned earlier, it's probably about 25 to 30% of the referrals that come in that we're actually able to get to mediation. But again, that's a consistent number across at least North America.
Okay, thank you.
Thank you, Councillor Nunciara. And now we bring it to committee. The Vice Chair, Councillor Janis.
Thank you, Chair. Through you to our witness. Do you charge a fee for providing these services?
No, we get a grant from the city.
And that grant covers your whole work? Would that be correct?
I am the sole full-time employee. I have Peter Brewer as my supervisor. And then I have a roster of approximately 45 volunteers who provide the service.
So if you were to get an increased load, that must mean that you must be getting a little bit more staff.
Possibly. We would have to look at that.
So if my grass is, let's say, more than the prescribed 20 centimeters and it's up to 25, and my next door neighbor complains about me, would this be a dispute resolution that you were looking to settle?
We could. Often when someone's worrying about 5 centimeters, there's something else behind it.
Well, if the bylaw officer were to drive by and there's only 5 centimeters, certainly, he will just move on. I mean, people make complaints to 311 regardless of anything. So how would you help unless the bylaw there's an infraction of the bylaw?
We get referrals through a number of different ways. Bylaw would just be added to the pool of what we get referred.
So the bylaw officer will drive by, take a look at this infraction, and then you recommend will refer this matter to you if it's more than 20 centimeters?
I would recommend that if the bylaw office is finding they're getting multiple complaints that they're finding often are not well-founded, and that there seems to be a certain amount of what I would refer to as tit for tat or back and forth, that they might want to consider referring it to us.
What's your success rate again?
If we can get both parties to the table, it's 80%.
Well, if I'm having a dispute with my neighbor, why would I want to be sitting at the table?
Again, often there's a lot of underlying concerns, and this would be a way for people to find themselves a chance to get heard on those concerns by the neighbor. Through our process, we build a level of empathy between the parties.
Let me ask this other question, if I may, through the chair to you. How many success rates of all the complaints that you have received, what was the success rate of you getting both the neighbors together?
As I stated before, generally our numbers are similar to the rest of North America, which is between 25 and 30%.
So then you're able to successfully conclude 25% of the complaints, so the other 75% of the complaints will still be out there dealt by the bylaw officer.
Exactly. So we're not taking any business away from bylaw, or a small amount of business.
And what is this costing the City of Toronto? What was the grant that your organization is getting?
To be honest, I don't have those numbers. Peter would, but I don't. I know that, as I said, we've been doing this for 30 years. About 5 years ago, we were increased when the North York service died, and we took over that area, and the city granted us to
So
cover that
if
area.
in my particular part of the world where there's a lot of rooming houses, if one house owner has turned his house into a rooming house and the rest of the street is complaining, how would you be able to resolve that?
In your part, in Scarborough, it would go through Warden Woods, but they approach it similarly to the way we do, which would be, in a case like that, we would probably try and do it, get all the parties together. So either have the folks who are complaining and see if they want to appoint a couple of people, or if they want to all attend, and then have kind of a roundtable discussion.
Have you, in your part of the world that you deal with, have you had any complaints about rooming houses that you successfully dealt with?
We have not had that kind of situation referred to us.
So the only situation you got referred to you is a fence, some grass cutting situation?
We also deal with landlord-tenant matters. We also deal with relationship matters.
Landlord-tenant matters are not part of the city. That's provincial, correct? Thank you.
Thank you. Any other questions? Councilor Mamaliri, please go ahead.
So let me just get this. You're getting city funding to help private neighbor disputes?
Yes. And Toronto Community Housing and a few other things.
Why would the city be paying anybody to dispute something privately?
The disputes happen. The city's paying us to try and resolve situations so that people can have a more harmonious neighborhood and a more harmonious and relaxed time in their private dwellings.
So if two homeowners are having a dispute about their home, I don't understand why the City of Toronto's taxes are going towards resolving a private dispute.
It was decided long before I was ever with St. Stephen's. But again, I believe the problem is that if it isn't solved, if we aren't resolving it, then it's going to bylaw, it's going to the councillors, it's going to
But shouldn't lawyers be
police.
involved if there's a private dispute amongst two homeowners? Shouldn't the lawyers be dealing with it?
Some people can't afford lawyers. Some people are shy of the law for various reasons from their multicultural backgrounds. This is a way to not create an adversarial situation.
Okay, thanks.
Any other questions? If not, I have a couple. First and foremost, I want to thank you for the good work that St. Stephen's House is doing. And I'm very familiar with the service that you provide. For the last, prior to my days as a city councillor, as an executive assistant to the former councillor, I did engage the service of St. Stephen's. So I'm going back to the last 25 years. So I have a couple questions that, in terms of bringing people together, very often when you have neighbors and they're disputing, whatever the disputes are, it's because they cannot get along and they will do anything in their power to complain against each other. How successful have you been in terms of bringing those parties together to have meaningful discussions?
Again, generally it's between 25 and 30% of the time that we can bring them together, given that it depends on how I refer to it as dug in any one of the parties may be. So that may be in relation to how much they want to or not resolve, or not want to resolve the dispute.
So if one of the neighbors objects to the process, then what? What happens?
It's a voluntary process. So if one of the neighbors absolutely will not do it, then we cannot do it at that time.
So nothing happens.
Again, we would turn it back to whoever referred it to us.
That's fair.
Yeah.
Now, once you have those two parties together, let's say in different rooms, what's the process of communicating, going back and forth from one room to the other one, or how does
We
it
bring
work?
them into the same room. We do some preparation ahead of time. We meet individually with each of the parties first for an hour or two. At a separate occasion, we would then bring them into the same room with the mediators, and we have a very structured process we use to help them learn how to listen to each other differently and how to respond to each other differently, and then we help them find a resolution.
In levels, in terms of expertise, we're dealing with bylaws, regulations that very often are very complex in nature. So from that perspective, in terms of expertise, because, well, some sort of expertise needs to be in play when you are dealing with people, especially people that are angry. And what kind of expertise do you have, is not necessarily you, but in terms of the service that you offer, do you have in terms of bylaws and so on?
Again, we're not necessarily worrying so much about the specific bylaws. We can ask people to do a little bit of their own research, or sometimes within the agreement, there's an agreement to go back to the bylaw department and get some clarification that they can then move forward. We want to repair the relationships so that they're not being in such separate and diverse camps, but that they can come together and resolve if it's something such as a bylaw issue, that they can resolve it in a more amicable fashion.
So in essence, the efforts are to bring people together in terms of repairing those relationships that at whatever point they were the best of friends and now they are enemies. And not necessarily to deal with the issue at hand, which could be more technical in nature as it relates to bylaws.
Possibly. A lot of the folks that we deal with weren't even necessarily best of friends, but in order to live next door to each other, they may need to be able to communicate with each other in some way that hopefully is respectful.
If there is any resolution at the end, is that binding?
Again, not through our process. In theory, they could go to a lawyer and get it brought through a civil process or something, get it notarized, whatever they feel might help. But generally, once we've resolved an issue, in the 20 years that I've been doing community mediation, I think I've only had something come back 3 times where they've contacted us and said, it's not working anymore, what do we do now?
I'll be supporting the recommendations from Councillor Holliday, and I'm putting another recommendation forward that I believe that perhaps there should be some sort of city staff facilitating these kind of meetings as it relates to the actual issue on dispute. It can be a fence, for example. And would you perhaps agree that would be a good start in terms of strengthening what's there?
Absolutely. I think anything that can help communities come together rather than seeing them fall apart is a very useful thing to do.
My last question, and very respectfully, actually all of the referrals that I have done during the last 2 or 3 years, and to St. Stephen's could not be dealt with because of the complexity of the issues at hand. So they were referred back to my office stating, sorry, we can't. We'd love to, but we can't. So that's when I'm talking about perhaps if something was to be facilitated by city staff as well, with your expertise.
Yeah, absolutely.
Thank you.
I think, too, though, that part of the issue, and I've had this conversation with Toronto Community Housing and with cooperative housing, is that sometimes we're so busy trying to resolve it, they forget to refer it to us until it's become too complex. So again, the earlier something's referred, the more likely we are to be able to help out in a more effective way.
Thanks so much. Thank you for your presentation.
Thank you.
The next deputant that we have is Derek Moran. Good morning, sir. Good to have you here. You have 5 minutes. Please go ahead.
I just want to start off by saying that I acknowledge and accept this subscribed oath pursuant to Section 4 of the Public Officers Act that you all took to be trustees of mine. It's interesting that an item like this is on the agenda, as it was Access to Justice Week last week here in Toronto. But I know exactly what you mean in regards to this issue, Councillor Holyday. My grandparents, who lived in LaSalle, Ontario, had a neighbor who thought we should replace the fence that was falling down, even though they were completely oblivious to the fact that it was their own kids and their friends that over time knocked it down by constantly running into it, playing basketball and hockey in their driveway. So in his letter, Councillor Holyday mentions the recommended motion submitted to the committee requests that city staff report back on possible improvements to the current process which would permit alternate dispute resolution to become part of the solution during the investigation and enforcement process. Councillor Holyday, do I ever have just the idea for you on a way for these people to get relief, remedy, redress for these ticky-tack matters with their neighbors that they're dealing with? This here, this is an excerpt from a law text describing the context of something called declaratory relief. Declaratory relief. A declaratory judgment is a formal statement by a court pronouncing upon the existence or non-existence of a legal state of affairs. A declaratory judgment is restricted to a declaration of the party's rights. It contains no provision ordering any party to do anything. Declaratory relief, being only a declaration of parties' rights, is mainly sought in commercial matters to help parties define their rights and as a means to settle matters amicably where reasonable people would otherwise disagree on their mutual obligations and wish to resolve the matter in order to avoid future disputes. In other words, a cause of action need not be extant at the time, whatever that word means, a party requests declaratory relief. Because declaratory relief is in essence a request for an advance ruling, courts have discretion to refuse such relief. This is the type of relief contemplated by Section 108(2) of the Courts of Justice Act, a declaration of parties' rights with no coercive effect or remedial entitlement. Now, this was from the Ontario court practice text from LexisNexis, and considering that, is he here? Considering that he was a Superior Court Justice, Councillor Matlow's father probably even has a copy of this has his own copy of this at home, and that maybe Councillor Matlow could bring it in and show it to all of you if need be. But this declaratory relief that I just described, this proceeding takes place in what's mentioned in Section 11 and Section 96 of the Courts of Justice Act and what's known as a court of equity. For instance, Section 108 of the Courts of Justice Act does a good job of explaining all the matters a court of equity covers, including the execution of a trust, relief against a municipality, and Section 108.2, subsection 10, which is declaratory relief. Now, I mentioned at the beginning how last week was Access to Justice Week. The problem with all this is, and I went over this with Sarah and Meredith who ran the event, that if I took any of you right now with me over to 393 University to, I think it's the 10th floor, no one there would have any idea about what I was talking about in regards to starting a proceeding in a court of equity. And I said this to Sarah and Meredith, and when I finished, Ms. Meredith even agreed with me and said, yeah, he's right. If you went over there, like he said, and asked about court of equity, no one there would know what you were talking about. And then both Sarah and Meredith agreed that that's wrong. Because as I said to them, the very name of this event is Access to Justice. It's pretty difficult to get justice from a court of equity when no one at 393 University getting paid to do the job knows anything on how to access a court of equity. So maybe that's something you could do, Councillor Holyday, work together with this TAG, the action group behind improving access to justice, increasing the awareness level for the people of Toronto in regards to amicably settling their difference with their neighbors in an alternative forum venue that wouldn't normally occur to them, such as the Court of Equity. Now, the easiest thing to do, Councillor Holyday, would be to just tell these people this. Pursuant to Section 32.1 of the Constitution, City of Toronto bylaws only apply to City of Toronto employees, and anyone who tells you otherwise is lying to you. You should take these matters before what's known as a Court of Equity. Otherwise, this is just another layer of bureaucracy being proposed that someone's eventually going to have to pay for, and you know that someone's going to be the rest of us by hiking property taxes accordingly to make up for the cost of it. So what I say to this item is objection, as I object to the idea to the creation of any statutory ADR to deal with such matters, as Ontario is a common law jurisdiction where the rules of equity apply also.
Thank you, Mr. Moran. Questions to the...
Take notice that Mr. is a term of... no, objection. No, wait a second. You referred to me as Mr., though. Okay, Mr. is a term of Admiralty Maritime jurisdiction.
Thank you, sir.
Subordinate inferior.
Any questions to the deputant? No questions. And yes, Vice Chair Karygiannis, please go ahead.
Thank you. Sir, I heard your speech with interest. Let's break it down in layman terms, in simple language. You're telling us what is proposed here is something that already exists. Would I be correct?
Yes, the Court of Equity, yes.
And this is something that was tested before, somebody from your family?
No, that's, like I just explained, not even the people who work at 393 University are aware of the Court of Equity. That's pretty messed up.
The Court of Equity, through the chair, would this something that is funded provincially, federally, or municipally? Would you know?
I assume it's whoever funds the court system. I mean, you know, taxes or security of the person.
Somebody pays for it.
Someone pays for it, yeah.
So what was proposed by the speaker before, I mean, what we heard from the previous speaker is that there's the executive director and that gets paid and they get a grant, probably also a grant from the city that looks after bricks and mortar, but everybody else that mediates is a volunteer. But the Court of Equity, it's been some sort of funding comes to the provincial, federal, municipal, like somebody pays for it. Where in the other instance, they're volunteers doing this.
Is that a question or a statement?
That was a question.
You have to take it up with Chief Justice Heather Smith. She's the one that runs the Court of Equity.
Thank you very much.
Thank you. Is any other questions? If not, thank you for your presentation.
And taxation is theft.
Thank you, sir. Questions to staff? Questions to staff? No questions to staff. Speakers, visiting members, Councillor Holyday, you are first. Please go ahead.
Thank you, Chair. And I'd just like to open by saying thank you to city staff that over the last few months have helped me get to the point that I could place this notice of motion. In particular, Imtiaz Ruffedin, Mark Saraga, and Carlton Grant. I think my colleagues around the table know exactly what I'm concerned about here. You're experienced councillors. You've seen this many times. You've seen the poison that occurs in your wards. In my preamble, I led to just one example of something that I've discovered over the last 2 years. I've called ground zero at this point in time, where there's 47 bylaw complaints across 18 houses. And when I stood on the street corner, the complaints were exactly where I could point my finger to. And we all know what's happening over there. I think the municipal licensing and standards staff know what's happening there. But they are very dedicated people, and they adhere to the process. And the process requires that if somebody makes a complaint, that it's investigated and followed through. We're not, neither us or the staff are there to judge. But there is something else happening in many of these situations, and as we heard from St. Stephen's House, there is a root cause often. And we've seen this at Community Council, and I know you yourself, Chair, and some of the other members of this committee have seen where we have fence exemptions that come in batches, and it's house after house after house, and it's clear what's happened. The fence complaint came in on the first house, and as soon as the bylaw officer got there, the fingers started pointing to the other houses, and we got a bit of a runaway situation. So the notice of motion before you, I don't think is radical, but I think it's a healthy change. And it is simply a report back to this committee, asking staff to give us some advice on if there's a way that we can do things better. And one of the things that I've asked them to look at is if there's a way to pause just simply pause when there is a runaway situation, where there is a neighbor-to-neighbor dispute, and that is hold off on the enforcement and see if we can get the quarreling parties to the table. You know as well as I do, and the many people that have contacted me since this story broke through the media and garnered some publicity, the amount of poison, even simply getting a letter to your house because someone has ratted you out on 311 for having your grass too long. People that go to the cottage for a week and their grass gets to be 8.5 inches. There's a big difference between that and when somebody is leaving a property derelict, when we have to come in and enforce that bylaw because the weeds are 3 feet tall. It takes up enormous amounts of staff resources. My preference would be that they are out chasing down criminal activity, dealing with body rub parlors, egregious bylaw offenses, and not looking at fences that are 1 inch too tall and chasing grass that's just a wee bit too long in the middle of the summer. I think you sense the frustration that I've had, the difficulty I've had in my community. I think it's happening all over the city. I suspect that if we can allow our bylaw folks to have a bit of discretion and detect when a situation has become runaway, and come back, and I look forward to the report on how that methodology will work, to simply get to the people talking and solve these root causes, cut down on their workload, cut down on the workload of the community councils, and really actually make the city a better place. Thank you.
Thank you, Councillor Holiday. Well said. And Councillor Nunziata, you're next.
Yes, just briefly. I understand from Councillor Holiday's frustration. I'm not sure what motion he's putting forward. What motion is he putting forward?
There is a recommendation, Councillor.
Oh, the recommendation
Yeah,
that's here?
in his
Oh,
yeah.
okay.
That's one, and I'm putting another one.
Yeah.
So.
You mentioned, one of the examples you mentioned in your letter is high grass and weeds, and I agree with you. I mean, if somebody's away on vacation for a week or something, it may be a few inches, but then you have other homeowners that have 5 feet, 4 feet of grass and weeds and all, and neighbors are going to call because if they live in a nice community, they don't want this property with high grass and weeds, and it's unsightly, so they call and complain. And staff have to respond to these complaints, and some of them come through the councillor's office, which in my case they do, and we forward them on. And if the staff don't respond and investigate, then you get complaints from the residents because nothing's been done, right? And why is it taking so long? So there really is a fine line, and I understand your frustration and what's happening in your ward, and I'm sure it's happening in other councillors' wards as well. But you know, I'm anxious to see what the report is, but I think that we have to be very cautious because there are a lot of legitimate complaints that come through our offices or through 311 that constituents expect it to be investigated in a response in a very timely manner, you know? So I think we just have to be careful. So I'm looking forward to the report and see what the report is that the staff brings back. But, you know, I have the mixed feelings on it because, I guess because of the number of complaints I get. And neighbor disputes, absolutely. We got a lot of neighbor disputes. And it never ends. It never ends. And it's just actually very scary at times because there's so much hatred that, you know, it concerns you that, you know, something's going to happen, you know? And you even get them in Toronto housing as well with tenants. You know, and St. Stephen's House, I've used their services over the years when it came to fences and, you know, because years ago in the city of York, we used to have a committee, the fence viewing committee, I think it was called that, where there were disputes that there would be.
We still have it.
We still have it?
Yeah.
Oh, okay, I didn't know we still had it. Citywide or?
Citywide.
Oh, okay. Which actually was very successful as well when it came to these fences, you know, and to resolving the issues. So, looking forward to the report. Thank you.
Thank you, Councillor Nunziata. The next speaker is Councillor De Vermaker, followed by Councillor Molidi.
Thank you, Mr. Chair. I'll be supporting Councillor Holliday's motion, and I think it's time that we asked our staff to give this some thought and come back with some recommendations. I think the system is as good as we can make it, but it's not where I think most of us would like it to be. I think I had one of the famous constituents who put in over 100 complaints, many more than 100 complaints, because she took offense to something and then just went up and down the street literally with a ruler and a clipboard and put in all these complaints. Harassed people that had never done anything against any of their neighbors, that had won Good Neighbor Awards, that had won gardening awards. These were wonderful people. The one couple with a hedge that was at their home when they bought it in 1958. 1958, they bought a house that had a hedge, and in 2015, I think it was, one of the neighbors complained about the hedge. They said the hedge was here 50 years ago. It hasn't been a problem for 50 years. But because it was 50 years old, it had grown out a little bit and was technically trespassing on our city boulevard. And when you saw where our inspectors told the owner where the hedge should be, which is sort of chop the hedge in half so that there's a 1 meter line from the sidewalk, you would just laugh or you would cry, depending on what mood you're in, because it was just so ridiculous. And unfortunately for us, we have to deal with these, and I know staff's job is challenging and difficult. But at one point, I thought we had the problem fixed when our executive director and staff said to me, we do not have to act on frivolous or vexatious complaints. Unfortunately, to determine if something is frivolous or vexatious, they have to go and do an investigation. So I have people, some with mental health issues, some who are just angry or don't like their neighbor for whatever reason, call our department and use it as a form of harassment. One gentleman, he went out to his swimming pool. He left his gate open while he was bringing snacks out for his family. One of our officers showed up because the neighbor across the street was watching him, and the minute he left his gate open, called our inspector. Well, you can imagine a gentleman in his bathing suit with his family serving snacks, how angry he was that he was having an inspector with a uniform and a badge on their shoulder and with a little notebook in their hand coming to make sure that he closed his gate. And this family has been a victim of that complainant over and over and over again. That one person who's harassing this number, I don't know if we would have reached 100 with this person, but it would be in the dozens and dozens of frivolous complaints. But as the inspectors tell me, well, Glenn, if we could get a complaint about a gate being open to a swimming pool, that's not frivolous. We have to go and inspect it. And Glenn, if the hedge is 4 feet 2 inches tall, that is a violation. That's not frivolous. That's a violation. And I look at, like I've been to the properties with our inspectors, and I stand there on the front lawn and I say, I can't imagine where's the violation? I've been in the building 20 years, 9 years as a staff person for Councillor Doug Mahood, 13 years as an elected official. I stand on a property, I can't see a problem. And the inspector will say, well, I'm not sure either. And they go through their notes and we have to measure this and measure that and say, oh yes, because this is a corner lot, this fence has to be that way. Or there's a little gap over here, or this fence is solid instead of staggered. It is staggering the minutia that people will go to harass their neighbors. So I think there has to be a way that our staff can deal with these frequent flyers, these people who are putting it, when somebody comes into our executive director with 100 complaints, they shouldn't inspect all 100 complaints. And they did. Every single one of those complaints was inspected. Every single one of those people was harassed. I had one woman whose hedge had been planted, her cedar hedge had been planted by her when she was a little girl with her father who had since passed away. They didn't realize at the time, because 50 years ago, that the hedge happened to be planted on the neighbor's property. And when the neighbor, who was a new neighbor, got the notice of violation that the hedge should be removed, the neighbor went out and cut down the entire hedge. A hedge that had been there for 50 years, that had been planted with a a father and his daughter. They were given no notice. The hedge just came down one day. This woman was in tears. And when I talked to the other neighbor, the neighbor was a brand new neighbor, a new Canadian, didn't understand the bylaws, didn't know his neighbor yet. He had just moved in and he just said, I got a notice from the city telling me to cut down my hedge, so I cut it down. This is something that we shouldn't be doing as an enforcement agency. I think our staff know who those frequent flyers are. They can usually tell pretty quickly when there's a personal issue involved, and somehow we have to, as Councillor Holyday said, press the pause button and not send our staff out as the complaints police being used by an angry person to harass their neighbors. We have to put an end to that. And right now, unfortunately, I believe it's still going on as we speak. And we've got to figure out a way, while upholding the spirit and the intent of our bylaws. If the hedge is only supposed to be 4 feet and it's 4 feet 2 inches, I know what the inspectors will tell me now. Glenn, that is a violation and we will prosecute them. We have no choice. We have to have some way of figuring this out. I don't know what that answer is yet, and I hope the staff will give it some thought and come back to us with a way that they can stop this abuse of the system from happening. Thank you.
Thank you, Councillor De Beermaker. Councillor Mamoliri.
I think someone's got to take carriage of Councillor Holyday's motion, and I'll do that. It's a report, so I'll take carriage of that. The report I'm looking forward to as well, and it's probably a long time coming. I believe we've been in somewhat of a crisis over the last few years in our neighborhoods. There are more and more people that are angry at each other than I've ever seen in my political career. And I can't really place my finger as to why that's happening, but it's happening. Neighbors are upset at each other, they don't like each other, and they will do and go to no ends to get on each other's nerves, including using their local elected officials to fight their dirty fight. And since 311 was adopted, I find that people are using 311 to fight each other more than what it was supposed to be about. And what is more challenging to all of us, and I'm sure that most councillors would agree to this, is that more and more of our neighbors are coming to our office and asking us to be the dirty person in their fight. I don't want to call 311, they say. I shouldn't have to call 311. I elect you as my elected official. You go after my neighbor because he's a bad guy, and they expect the elected officials to do that. Now, there's some merit to that. I mean, we mediate all the time. Councillors try to bring people together on a regular basis. I know I try to do that as best I can. There's no legal agreements. There's no taxpayers' dollars given to that kind of service. Neither, and there shouldn't be. And this is the part of this that I'm not going to support. At the end of the day, I don't believe we should be giving taxpayers' dollars to any mediation for any private citizens that have an objection to each other if it's a private matter. I don't know why we're doing it, and I'd like to find out how much money we're actually putting into this. And the gentleman that was here earlier was absolutely right. There's a provincial process for people to help mediate. And if anything, we should be pointing people to that particular process and saying there's tax dollars already going towards this sort of thing, and that's provincially. This is a prime example where we want to be everything to everybody. We can't do that. If you're going to do that, and I'll say this to Councillor Holyday, I know he agrees with me on this, I don't think we should be doling out all kinds of money for mediation, because in my opinion, it doesn't work. Neighbors are upset at each other, they hate each other for a reason, okay? And they're not going to come to the table. I think it should go towards arbitration. I think if you're going to do this, if you're going to create some kind of a system, another level of bureaucracy, which I disagree with, but if you're going to do it with an arbitrator that says, I've looked at your case, tough luck, you've lost, your neighbor's won, right? And end it. Right? That's the only way to resolve these particular matters. If you're going to start doing this, it's going to get even worse than it is today, because they're going to actually believe that the municipal level of government will deal with whatever complaint they have about their neighbor. This is no secret to me. I have said to my colleagues on community council who have had to hear my neighbors come and dispute their problems to my own colleagues over the last few years. And so much so that I give a video out. And I'm not sure if you, how many of you are over 50, but if you do, you'll remember this video that we were all shown when we were children in public school. And it was a video about two neighbors that had a dispute of a tree that grew right in the middle of on the property line. And there was no talking in the video. And it showed two neighbors loving this tree so much that they started to hate each other because they wanted ownership of that particular tree, to the point where one of them kills the other, they both kill each other, and they kill each other's families. They build a fence where on their side of the property where the tree is. We were shown this when we were children, and that had so much impact on someone like myself that couldn't understand why two neighbors were fighting so much. Maybe that's the solution. Maybe everybody should just get a copy of the damn video, right? And maybe they'll just stop fighting. I don't know. But at the end of the day, tax dollars shouldn't be put into mediation. I disagree with that completely. Throw it into arbitration and tell the neighbors to stop fighting, or else. I've had people that have thrown feces at each other in neighbors, people that own properties, upset at each other. They put cameras now to watch each other in what they're doing every single day, right? And they're expecting the city to defend them when they're scrapping with their neighbor, right? I think if anything, they should both be fined, and at least the services that they continually get to their door, that continually, it's a cost to the taxpayers. At least they should be paying for those services if this thing becomes an ongoing thing.
Thank you, Councilor Muliri.
Maybe if they did that, they would stop complaining.
Is Councilor Di Giorgio?
Thank you, Mr. Chairman. Picking up on the tree situation on the property line, I find in today's environment that usually the dispute between abutting neighbors, one wants the tree up and the other one wants to be taken down. That's the kind of situation I run into my own ward. But I welcome the motion put forward by Councillor Holyday. I caution for a number of reasons, and I would ask staff to perhaps compartmentalize their report and bring forward their report based on different types of bylaws that are being violated. For example, there's a property standards bylaw, which I think this particular motion is focusing on more than anything else. And we have, when property standards are being violated, we have a process in place or a mechanism in place where someone can ask for relief, take it to community council. If it's a hedge that's too high or if it's a fence that's too high, we at community council are not mediators, but rather arbitrators. We make a decision and it's final on relief. There are bylaws related to that are legal non-conforming for a status, for example, related to a hedge that presumably we can't do anything about. And that's because the hedge was in place prior to bylaws that come into place that don't allow that kind of thing. But notwithstanding that, the hedge is grandfathered and there's nothing you can do about it. Then we have bylaws that are related to use. For example, neighbors, one neighbor might be conducting a business next door to another neighbor who has a residential. They figure there's no way a business should be operated in a residential neighborhood. And in particular, I'm looking at someone who's conducting a body repair shop in their own garage right next door to a residential use. And that's really a clear, and that's a function of opinion, by the way, because bylaw enforcement might say, well, we can't catch them in the act. And to me, it's clear cut. Is it a use that's permitted or is it not? It's very, very simple. And we should be prosecuting on that basis. And I, for one, cannot understand why we are reluctant to prosecute in situations like that. Then we have bylaws that are related to, I call it self-interest. If we have somebody that's building a new home next door to somebody else, and there's a fence there, and the person that's building the home somehow because of constraints on the lot, manages to either do some damage to the fence or damage to the abutting property owner, those are self-interest things. The abutting property owner sometimes invites someone building a new home to cause damage to his property, so he can then seek repairs and whatnot. So there's self-interest sort of bylaw situations where violations are occurring. So all I'm saying is, and I appreciate where the Councillor Holiday is coming from, so I look forward to the report as well, with a view to making, I think we should be more of an arbitration kind of situation. We council should arbitrate on situations where, and not look to mediation sometimes, because mediation really is a function, well, I see it as a proper mechanism. I'm just not sure what is the right way to go in some of these cases. So I'll leave it at that.
Thank you, Councillor Di Giorgio. Vice Chair Karygiannis, you're next.
Thank you, Chair. I've listened with interest to the deputants, and I've noticed that we do have something in the legal system, Court of Equity, I think it was called. I also listened to the deputant regarding the mechanism that we have that only is successful at settling 25% or getting the people at 25% of the dispute. If there's two neighbors fighting, trying to get them into a room, when there's no, this is voluntarily, I think you're going to have difficulty trying to get them into the same room to discuss it with each other. 25% success rate could be high in that instance, but I also say to you that it doesn't matter what we have or what we don't have in place, the neighbors are still going to call 311, they're still going to call the consular officers, they're still going to try to use us as a means of settling their disputes. I have a neighbor right now that is disputing her neighbor about a garage that was built in the back, and I've seen these emails go back and forth, and I feel sorry for our building inspectors and our bylaw officers on the amount of I don't want to say abuse, but the amount of work that they have to do in order to try to tell one neighbor, get on with it, and this is allowable. I also receive a lot of general concerns from people that the tree could be, the hedge could be, a couple of feet long. And a lot of people that sometimes are complaining, they don't want to put their name forward. I'm complaining to you, I want you to take care of it, but I don't want you to disclose who I'm complaining about. So when you arrive at the neighbor's yard and say, listen, your grass is too high, would you please like cutting it? Oh yeah, it was this person around the corner that snitched on me. There's always, in a particular neighborhood, there's always somebody that's called a snitch, or somebody that likes to take on their own hands the matters of bylaw. So although I'll be supporting Councillor Stephen Holliday's motion, and I want to thank my colleague, Councillor Mammoliti, for carrying it forward, I say to you that 25% success rate is high, and it's probably less work that our bylaw officers have to do, but this problem of neighbors fighting each other will never go away. And if the neighbor thinks that I can get away with calling 311 or getting the bylaw officer there, then they will use that mechanism versus taking time off work to go and sit in a mediation. There's very limited success rate that people will come to the table if they're fighting each other. And sometimes, as we've seen it a couple of weeks ago in Scarborough's Community Council, there was two neighbors fighting over a hedge, and they've been at it since 1979 because the previous owner built the second floor, and the guy that was complaining now doesn't like the second floor. So unfortunately, this is the nature of the beast that we have to deal with, and should we have greater success in this, so be it, but I'm supporting it with hesitation.
Thank you, Councillor Karygiannis. Any other speakers? If not, I'd like to say a few words. First, I want to thank our esteemed colleague, Councillor Holiday, for bringing this communication forward and his recommendations. I think they're very meaningful. Also, I would like to thank the deputants for making excellent deputations as it relates to this one. I would like to move the following recommendation. I did check with our city staff on this recommendation, and if we can display it. that the Executive Director of Municipal Licensing Standards be requested to investigate the feasibility of A, any alternative dispute resolution process be facilitated by city staff, and B, the dispute resolution process be mandatory to all parties involved. And Councilor Mamoliri spoke about the disputes about neighbors, and I will encourage you perhaps to bring that video to City Council for that to be extremely beneficial. I've seen it at the local community council, how it's an eye-opener, and that would be of a great value to all members of council and city staff as well to look at it. It's an amazing video. Now, with I'm sure that all of us, all members of council at whatever point, we have received all these types of complaints from neighbors and disputes, and very often we get complaints that are not even within the city's jurisdiction, where the city doesn't have the authority, not even to inspect the location. So the onus is on the member of council very often to advise the constituent that if they want to proceed further, that it should be under civil litigation they would have to take to the courts. So that's something that probably we haven't even talk about, and that probably would be important maybe just to bring that also within the report, and I will suggest that to the Executive Director of Municipal Licensing, maybe just to look into it as well. Now, a lot has been said about bad neighbors, and I will venture to say very often we have neighbors from hell. And there are some people that, for whatever reason, and the ones that I know, they've been the best of friends with the next door neighbor that now they're disputing everything under the sun. And that's where all the complaints that we get in terms of either if there is an infraction with front yard parking, fences, all kinds of encroachments, widths, you name it in terms of property standards. But other complaints, if they can't get his neighbor or neighbors on property standards, and then they will elevate to something else in terms of zoning infractions. Or my neighbor has multiple dwelling units, an illegal rooming house, or you name it. So, and that takes an enormous amount of precious time, not only from our own offices that we are very busy, but from our city staff. And that's a waste of time. So I do understand the process, how it works. And one of the reasons that I'm putting this recommendation forward is if there is going to be a process in terms of mediation, that it has to have some feet to it as well. And I think that if we are serious about it, our city staff, they do have what it takes in terms of knowledge on multi-disciplines in terms of enforcement on a number of bylaws. So I think that would be important maybe to bring forward something that's comprehensive and something that could be enforceable, and at the end that hopefully a compromise could be reached that's satisfactory to everyone. Thank you, and I will urge that the recommendations from Councillor Holliday is be supported, and I'm going to ask for a recorded vote on this one. Thank you. And so we can take them as a package, and to adopt the item as amended. All those in favor? Councillor Di Giorgio, Di Vermaker, Marlowe, Palacio, Carigianes, and Mamoliri. Unanimous. Thank you so much. Can I have a motion to adjourn? Councillor Mamoliri, all those in favor, against? Thank you so much. Have a wonderful rest of the day.